Hello and good morning and good afternoon if you're on the other side of the pond. Welcome to this webinar from Gardner Law and Field Fisher. We're excited to share with you about especially some topics that follow GDPR. If you're familiar with the General Data Protection Regulation in Europe, we have new things that are on the horizon and also have come recently. So we'll be sharing about that today. I'm excited to have Oliver with me as well. So we'll be co-presenting and discussing some hot topics both in Europe and in the US that relate to data and add on to what we know as the GDPR. If you're familiar with Gardner Law, we have a practice that focuses on FDA regulated industry. So we have four main practice areas: FDA regulatory work, privacy, which includes HIPAA, state law, and some international privacy law, as well as federal law, and then compliance. So we also work in anti-kickback, False Claims Act, Sunshine, and related activities. And of course, recently we've added some litigation support as well. So with that, I'll go ahead and hand it to Oliver to get us started on the EU Data Act and provide some insight on this new law.
Yeah, many thanks, Paul, and good morning and good afternoon, everyone. Yes, I'm very happy to give you a brief update about what's going on in Europe. I will start with the presentation now, and I'm not sure if I will manage the slides or if that will be done automatically. But anyway, the topic today is the new European Data Act, and I know that we have in the majority folks from the US in this webinar today, and maybe for you this comes a little bit as a surprise and out of the blue. So let me start by giving you some background and context about this new European Data Act regulation. It's actually one of the central pillars of the European Commission's data strategy, and the goal is to set out a framework for the use of data within the European data economy. And as you can see on this slide, it has a very broad scope, and it especially covers products in the IoT sector, smart devices and related services to such smart devices. We will come to more details in the course of the presentation. With regard to the timeline, it's very important to note the date of September 12, 2025. That will be the date when the Data Act will be applicable, which means that companies now have a little less than 1 year to ensure compliance. With regard to the territorial scope, it's important to understand that, again, the market location principle applies. Many of you will remember that or are aware of this principle from the European General Data Protection Regulation that follows the same principle, which means in a nutshell that the decisive factor is placing on the market of a product, in this case, or providing related services to such products in the EU. And it's not relevant if you're a registered office in Europe or if you even have an establishment in the European Union. As soon as you provide products on the market that fall under the scope of the Data Act, you will need to be compliant with this new regulation. And the important thing to understand, first of all, is that different to the GDPR, the Data Act deals with non-personal data. It's applicable in the B2B sector as well as in the relation to consumer, or in the life science sector in the relation to potential patients that are using medical devices. And as you can see here, it creates a very complex regulatory framework because the Data Act complements the GDPR. The GDPR still has priority for personal information, whereas the Data Act covers machine-generated data. And the thing about machine-generated data or machines and products that fall under the scope of the Data Act is, of course, that these products can also include personal data. And as soon as that is the case, you would need to pay attention to the GDPR plus the Data Act. And then, in addition to that, as soon as smart medical devices are also containing AI components as defined under the European AI Act, you would also need to pay attention to the European AI Act. These three regulations, as you can see here, create quite some overlap and dependencies, which really brings us into a very challenging regulatory landscape. There are three key goals of the Data Act. We will focus today on the first one, establishing a framework for data sharing and a data economy in Europe. That's the focus today, and even this focus will be narrowed down to some, what I would consider the most important topics. The whole act is very complex, so we will not be able to refer to each and everything that might be important in addition to today's webinar. But this first focus is the important thing today. Beyond that, the goal is to making non-personal data mobile, putting data into circulation. And also the third part might be important for some of you, even though it's not topic today, which is to facilitate switching between providers of data processing services, in particular cloud service providers, to avoid lock-in situations. But again, today we will focus on the first part of the three goals that the Data Act wants to accomplish. So let's have a look at the products or services that are subject to the Data Act. It applies to, more or less every connected product, and connected products under the Data Act are defined as items that obtain, generate, or collect data concerning its use or its environment. And as a second requirement, these products need to be able to communicate product data, either via electronic communication services, the physical connection, or whatever. So this combination, which is typical for everything in the IoT sector, and is also typical for many smart medical devices, is what is very much in the focus. So it's very product related, but it also covers related services to these products. You see the definition of these related services here on the slide. So actually this means any software or updates like navigation services or even cloud-based smart TVs, platforms, building software, everything that is a software but is related to a certain IoT product can be covered by the Data Act as well. And then let's have a look at who's the addressee of the Data Act. So in principle, you can make a distinction between three parties that are subject to the Data Act and that play a very important role with regard to the obligations. First of all, there is what the Data Act calls the data holder. That would be in case of the life science sector, for example, a medical device manufacturer. But in a broader sense, the manufacturer of any IoT device or product, this would be the entity or the legal or natural person that is able to use the data that are produced by third parties, by users when using these products. Then you have the user, which would be, in case of a medical device, either the patient or a hospital that has either rented or leased or bought a product from a medical device manufacturer, which is the party that is producing the data by using it or by letting it use by patients or their customers. And then there is a very important new party created under the Data Act, which is the data recipient. We will see later in the presentation that there can be the right of a data user to ask the data holder to share data also with third parties, with data recipients. And that can, for example, be every kind of aftermarket service providers. For example, a company that helps the user of a certain product with the maintenance. And in order to do so, they would need the data that are produced or by the usage of this product. And that is exactly what is the goal of this Data Act, having a right to make the product data also available to such third parties in order to foster innovation by services that are not directly related to the product, but that could be used by a user for a certain product, for a specific smart device. If we go to the next slide, you can see an overview about what is data at all under the Data Act. This is only an excerpt of a number of definitions under the Data Act. You can see that it's very, very detailed. Not every category of data that you see on this slide will mean or will have a consequence in terms of certain requirements or obligations that you might need to follow. The most important actually is the last category, the so-called readily available data, because these data are subject to the right of making data available either to a user as per the request of a user, or also, as I said earlier, to third parties, to further data recipients that might be interested in the data that are produced by a certain product. So if we look into that in more detail from a data holder perspective, you can see here that that's very important, that not only the manufacturer of a smart product is covered, but also manufacturers of smart components that are delivered to the manufacturer. And you can see that in particular, for example, in the automotive sector, where you have a lot of component suppliers, and many components are smart products itself. And then these components would be delivered to a manufacturer. And in this case, also the component supplier would be subject to the Data Act. And that is not maybe so interesting for the medical device sector, but still this gives a good overview, and this is actually taken from the FAQ that the European Commission have created also in order to provide some guidance and make it easier to understand the goals and how to comply with the Data Act. So as soon as a manufacturer would place a smart product on the European market, you would be covered by the Data Act, and the obligations go along the value chain, as you can see here, of any industry as soon as it's an IoT product. That's the thing about this slide, and then we can have a look at the spotlight that I would focus on today, because the Data Act brings some important changes with regard to the question how, as a data holder, I can use product data for myself in the future under the Data Act. And as you probably know, using product data for the own purposes of a manufacturer is very important for many reasons. That can be for further developing a certain product, for analyzing usage patterns, or for more general product innovation. That is only possible if you can use the data that is produced by the user of certain devices that are placed in the market by the manufacturer. So in order to understand this principle, it's important to understand the role that the user has from the perspective of the legislator, from the European Commission, from the European Parliament. And this is very understandable if you have a look at recital 18 of the Data Act, which says that the user is bearing the risks and is also enjoying the benefits of using a connected product, and that therefore the user should also enjoy access to the data that a certain product generates. That actually grants the data user a quite strong position, and that is exactly the goal of this Data Act, not only to grant this strong position to the user, but putting the user of a product in the position to request access to the data for himself or itself as a legal person, but also to ask for sharing these product data, as I said, with third parties. And this has been as explicitly established in Article 14 of the Data Act, Article 14, Section 13, to be more specific, which says that a data holder, which again is the manufacturer of a certain smart product, shall only use any readily available data, that's the category I mentioned before, on the basis of a contract with the user. In other words, in the future and as soon as the Data Act applies, you can not only just, as you may do it today, use the data of a product for innovation purposes, for developing purposes, but you would need a basis in a contract with the users, which means if the contract currently does not provide for such a basis, you would need to adjust your contracts in order to have a legal ground for using product data for your own purposes in the future. That's, I believe, a very important change compared to what many companies are practicing today in Europe. We can see that here again at the FAQ of from the European Commission, and that demonstrates that also the Commission is very much aware of the fact that this is kind of a game changer. In section 26 of these FAQ, the Commission explicitly says that while the GDPR governs processing of personal data, the Data Act covers the use of non-personal data. That's what I already mentioned, but it explicitly refers to Article 4, Section 13, and underlines again that you need to have an agreement with the user if you want to use product data for your own purposes. And if we look at that from a more contractual perspective, then in practice, this means that you would either enter into a new contract or would adjust existing contracts between a manufacturer and a user. If we move on in the slides, you can see here the parties that would need to enter into a contract. And we have also some examples here of what this contract or the sections in this contract would need to cover. For example, who would like to use these product data? Is it just the manufacturer? Is it other companies in a group of companies? What is the purpose of using these data? Is there a disclosure to third parties within a group of companies? How long would a company like to use this data? Is it an exclusive usage? And so on and so forth. All that could be or has to be part in the future of the contract between the manufacturer and the user, client, in other words. And to the extent that you would be a component supplier, the same would apply. I think that's not so important for our webinar today, but the key message here really is that as a manufacturer, you would need to enter either into new contracts or most probably adjust the existing companies to have the opportunity also in the future to make the use of the product data that are created by the usage of a certain smart product. And besides this, we also, and that's what I mentioned already earlier, have a very interesting new obligation for making the product data available not only to the user, that's another thing that is established by this Data Act, but in particular also to third parties. You see the relevant section of the Data Act on this slide, and that makes clear what is regulated here. It's important to understand that, of course, you are not requested to disclose any data that you're not available of. If a certain product just does not create certain data, there is no obligation to disclose this or share it with third parties or provide access to data that are not existent to a user. It's again, first and foremost, the case for readily available data. So every kind of data that as a manufacturer you could easily access would be data that you are also obliged to make accessible to a user or even to a third party, as you can see here, upon request of the user. During the legislative process, there has come up, can we go back to the previous slide just for one more second, please, about how to deal with trade secrets. And of course, there are exceptions for trade secrets. Everything, that is a trade secret is not subject to these requests for sharing data. That's an important exemption. and the Data Act is dealing with that quite extensively. So just if this question should come up, there's of course relevant sections that are dealing with trade sections in the Data Act. Another principle, and with that we can go to the next slide, thank you, is the right, the principle of access by design. If you have dealt with the GDPR in the past, or you're still dealing with the GDPR, you might recall that there's a similar principle under the GDPR, which is the principle of access privacy by design. And this is very much a similar principle. It basically says that even already when you create or develop a certain smart product, you need to consider this access by design principle from the very beginning, which means a smart product has to be designed in a way that puts you in a position to provide access to the data it produces to the data user or potential third parties, which also means that it's in the hand of a manufacturer or developer to create a product in a way where it can provide access to certain data, because only if data is available, you can provide access to these data, which in other words means that if a product is created in a way that it's not able to provide access to certain information, certain usage data, then of course you are not obliged to share this data with any third parties or provide access to it upon request of the user, which means, again, it's very much in the hands of the developer, of the manufacturer, and depends on the design of a product which data are available at a later stage or not. This one has actually already been mentioned, the right to data access. The data must be made available to a third party upon request. And the data holder and the data recipient must enter into a fair, reasonable, and non-discriminatory and transparent agreement that is regulating between the parties if and to what extent the data should be made available. The EU Commission has announced that it will publish proposals for contract clauses in summer next year that will make it easier for any market participants to comply with that. But it's important to understand that the Data Act will bring substantial new requirements to all contractual relations between a manufacturer and their clients. There are also, we can already go to this slide. Just to sum up a little bit, what are potential next steps for everyone to be prepared and to be compliant until September next year? What we are currently recommending our clients is to start with a product assessment. The first step, of course, is to assess whether the products of a certain company are smart products in the sense of this regulation, and also if there are potential related services that fall under the scope of the Data Act. That would be an important first step. And depending on the complexity of the product world of a company, that can, of course, take quite some time. Once you have identified the products that are relevant here, it would be advisable to review the contracts that come with these products in terms of the requirements that I briefly presented in the previous slides. And most probably there will be the need for adjustments of a number of contracts with regard to the legal ground for using product data for your own purposes, but also with regard to new user rights and the data sharing obligations that I mentioned. The protection of trade secrets and intellectual property is, of course, important as well. That needs to be assessed. Is there information that comes with these products that you would like to protect? The access by design principle is something that is important to consider in the course of a compliance project here. And finally, the provision of comprehensive information about the network products before the contract that also come with the Data Act is an important part that you should pay attention to if you get prepared for Data Act compliance. That's already it, a very brief overview. I just wanted to flag some of the aspects that I consider important, in particular in the medical device industry. And with that, I'm happy to hand over to you, Paul. And if anyone has any questions, please feel free to reach out to me anytime. Many thanks.
Hey, Oliver, before you drop off, I had a question I thought may be interesting to our listeners. What about, in terms of this new regulatory effort to implement general data control and oversight, how does that, if you have a GDPR program in place, how can you, perhaps leverage what you have already, operating and ready to comply with GDPR or some of these other laws? How can you align that with this and make that process easier?
That's a very good point, because in particular, in terms of the processes that you might need to implement into a company, you will probably not need to reinvent the wheel in any case, right? So also already under the GDPR, you have the obligation to provide certain information to data subjects if they request, if they ask for deletion, if they ask for information about the data that you have processed, of course, in terms of personal information. So if there is already a process established, you can use this process also, of course, for the obligations that come with the Data Act in terms of non-personal data. So that's something that you could leverage. But still, with regard to the contractual adjustments and obligations, this creates something completely new. In other words, there are also parts where the GDPR and potential GDPR compliance doesn't help at all. And that's exactly why I recommend my clients currently to get started, because September 12th next year sounds far away. But again, depending on, the complexity of the product world and the size of a company or group of companies, there are quite some things to do.
Thanks, Oliver. I think that really helps. And by the way, we didn't mention earlier, but feel free to chime in with questions in the chat as well. I think that function's enabled. So feel free during the program to ask those questions, and we'll get to them when we can. And if you have some for Oliver, please input those, and I'm sure he'll be able to answer those at the end of the session as well. Or as you noted, feel free to reach out by email and get a hold of them that way. Okay, so let's go ahead and get started on the US update. So just briefly, there's been a lot that's happened over the past few years in privacy, and we've talked about that throughout the last couple of years. US privacy updates in state law, we have a significant shift over the past now 4 or 5 years in terms of how is privacy enforced, who is doing the enforcement, what sort of laws are in place and apply. So we're going to talk some about new developments, things that we're seeing in the past year, and then especially talk about enforcement and how that's been trending in the past year or so, and then discuss a little bit some of the impact from the federal government in terms of enforcement, what we've seen in the past few years and the last year especially, and continue from there. So let's get started. You already see me, so we have another picture here, probably a better picture. And then briefly about me, I've been practicing in privacy for a little over a decade now, and primarily focused on healthcare privacy. So we work with, whether it's med device companies, pharmaceutical, healthcare organizations that are dealing with this complex overlap of privacy, whether it's HIPAA, state laws, federal laws, sometimes international laws, and in all these contexts, from clinical trials to interacting with patients or interacting with doctors, there's a lot of complexity in that space. So that's where we specialize. So here we are. We've got a lot of state changes. We'll talk about those, some new state laws, some legislative activity, some rulemaking activity in the US, and then enforcement. We'll talk about it from a state perspective, which has so far been fairly light, and we'll talk about why that is. And then also some federal enforcement, which has not been as light. We've seen a lot of activity from the Federal Trade Commission in particular in privacy. And then we'll wrap up with a couple of other considerations. There's some unique ways that privacy has been impacting companies, and we'll talk about some of those and then conclude there. All right, let's go ahead to the next slide here. So as you can see on this slide, there's been significant activity, and these are the states that have passed either a comprehensive privacy law or, relevant to our audience, consumer health data laws, like Washington, Nevada, Connecticut. There's there's no shortage of privacy things or requirements or considerations to take into account, and these state laws are a big driver of that. Most of these laws are already in effect in this full list. This short list here of new laws that have passed in the past year or have been significantly amended in the past year, these are generally not in effect now, but will be in effect within a few months or within a year or so of now. So Rhode Island and Kentucky will be effective January 1, 2026. We'll be seeing Minnesota and Nebraska, July 31st, 2025 will take effect. And New Jersey, we'll see a January 15th effective date. And then New Hampshire made some significant updates that'll be effective January 1, 2025. And then Maryland, kind of in the midst of that, will take effect October 2025. So we have a little bit of time as these come into effect, but as you've heard, some of them are taking effect January 1 of next year. And then the others will follow in sort of a falling pattern. What's helpful to realize with many of the state laws on the books is that while some are kind of in this grace period or right to cure period where companies might have a violation or have a violation identified by a regulator or attorney general, that doesn't necessarily mean that a public enforcement action will take place, because in many cases these laws have a opportunity to fix that within the first year or 2 or 3 or so of the law's existence and effect, but that will eventually sunset and enforcement will start in earnest. Of course, there are some states that have already passed that period and are now fully implemented, fully addressed in enforcement, and we'll talk about that. So a few of the states have already implemented rulemaking. So we're seeing that in Florida, which has started kind of in a unique way through this digital bill of rights, regulating a very specific type of company. So we won't dig into that too deeply, but if you're familiar or aware of the Florida law, it's designed to address some very large, very specific industries where businesses handle large amounts of personal information. But what's unique about this and could be something to keep an eye on is this idea of requiring certain entities to comply with cybersecurity standards that are stricter and more specific than has typically been the case in privacy laws to date. So something to keep an eye on is that if that will become a trend potentially in rulemaking to identify specific cybersecurity standards or frameworks. So far that's not been the trend with various state privacy laws, but that is something to keep an eye on. California, of course, has continued its rulemaking. We haven't seen a lot of action that's led to concrete movement in 2024. There was that early in the year that case that led to a appeals court saying, look, we recognize that there is no required delay for this proposed rule that was pushed through in October last year. So instead of that taking effect in October of this year, it was kind of abruptly made effective in March this year. So we have seen that take place a few months ago now, and that's been in effect for some time. Largely that impacted companies in terms of how they handled their online presence. So if you had a website and you had opt-out rights available on your website as required by the law, how you specifically implemented that would have been affected by these rules. Similarly, if you had any privacy policies, there may be some impact from those rules as well. So please, if you haven't looked at that yet, that's already in effect. So take a look and understand what California is doing already. From a future-looking standpoint, we aren't seeing any existing drafts that have gotten past sort of the proposed draft stage. So they're not formally entering rulemaking on automated decision-making and risk assessments the way we may have expected at this point. There were some drafts that went before the California Privacy Protection Agency board, and in July those were passed over with concerns really about, okay, are these too broad perhaps? Do they too negatively impact things like automated decision making or artificial intelligence? Are the risk assessments too broad in what they require? So we'll probably see some new drafts relatively soon on that, but right now there's not any existing rules to consider there. And on this similar note, there's been some amendments made to various state laws that, while not rulemaking, have some similar impacts. California decided to add an amendment to make that threshold that the CCPA only applies to companies that have a $25 million annual revenue, tie that requirement to the consumer price index so that it'll elevate over time with inflation. So that's one amendment. We've also seen an addition, which probably won't have a huge effect in terms of actual law, but does emphasize the point that neural data can be sensitive information, so data collected from the brain. We've also seen some clarification that personal data that's existing in AI systems, that then the AI system can be capable of outputting personal information. So therefore, there's some regulation of those systems and the data within those systems, even though kind of typically you wouldn't think of an AI model as being a personal data system. You know, the data inputs might be personal data, but the system itself may not be. But California clarified that when it comes to systems that output personal data, potentially that those systems may involve the processing of personal data directly. So that is a clarification that has some impact and may have impact to companies that handle this kind of information and run AI models. Colorado added a duty of care for companies, particularly around minors that use online services or products or features. So there is an additional heightened risk evaluation that needs to take place when there's minors using online services. There's also biometric protections that were added for the employment context, which is an additional consideration then for employers with employees in Colorado. And additionally, similarly to California, but with a similar effect, neural data, data collected from the brain was added as identifiable sensitive data. So there's a kind of a trend you can see in some of these amendments. Lastly, Virginia made some expanded data minimization provisions to its comprehensive privacy law and added some risk assessment requirements for children's personal data. And there were about a dozen amendments being considered in Virginia, but only one ultimately passed. So that something to keep an eye on is continued updates in Virginia in the next legislative session. And then I think that's about it for amended state laws, but we do see that continuing to be a focal point is that legislatures want to improve or close loopholes or make adjustments to these laws that are on the books. Let's talk about state enforcement. So state enforcement, and we'll dive into a couple of examples here with Tilting Point Media being one. Overall, state enforcement has been a little bit lagging because, as we mentioned earlier, some state laws aren't really taking effect in terms of enforcement and public enforcement for a period. So there's a period, and California had a similar period early in its the development of that law, where a company might be found to be lacking, but there is still an opportunity for them to cure or correct the issue within 60 days or some period once that is identified by the regulator. So that's the case in many states. Additionally, some of these laws haven't taken effect quite yet. So we have those 7 laws we just mentioned earlier in the presentation that are brand new, and those don't have effective dates that we've reached yet. So for that reason, enforcement really hasn't taken off fully, but we do see a couple of states, with California being one of them, where maturity has been reached to the point where there's an established regulator, there's been some track record of regulation and enforcement. I want to point attention to a couple of these cases in California in particular, because I think they're informative. In this case, Tilting Point Media LLC is a games developer that produced mobile games that were targeted for children in particular. In this case, there was a $500,000 settlement reached, along with some stipulated requirements for that business. And go to the next slide here. So a significant part of this was that the complaint alleged the mobile game developer collected and shared children's data without parental consent. So that would be a violation of the California Consumer Privacy Act, the Children's Online Privacy Protection Act. And so this was essentially a combined effort from the Los Angeles City Attorney's Office and the California Attorneys General to identify this particular mobile game called SpongeBob Krusty Cook-Off was directed to children under the age of 13, as well as targeted for older teens and adults. So what they didn't do that was pointed to is that there was an age screen that checked the age, but it didn't ask for the age in a neutral manner, saying, for example, enter your age correctly to be directed to a child's version of the game or something like that. Instead, it was kind of this, are you a child or not? And then children were directed and pushed towards using a standard version of the game that shared and collected data without prompting a parent to be involved. So this is something that was an emphasis point and tends to be an emphasis point, is children's data. And by regulators, as you can understand, that could be a very popular and important, critical, however you want to put it, sort of protection. We want to protect our children. So there's emphasis and focus on this from regulators, and very understandably, and companies need to take note of that. And then another recent case we've seen just this year, DoorDash, and among some other companies, but DoorDash was the focus of this investigation and ultimately a settlement. DoorDash was involved in what was called a marketing cooperative, or a couple of these marketing cooperatives actually, that essentially the concept was that they would join this cooperative, and then these other companies and DoorDash would share personal information about folks using their application, their systems, in order to help cross advertise between companies towards these individuals. So the consumers were, working with DoorDash and downloading the app using DoorDash, and then their information would be shared with this cooperative, and eventually targeted advertising would come from these different parts of the cooperative. Of course, the government took issue with some of the activities here, noting that, look, there's not really any evaluation or opportunity for folks to object to this kind of sharing, which is required by the California Consumer Privacy Act. If you share information for any kind of benefit to the company that you're sharing it with, rather than sort of a service provider relationship, there becomes, in the eyes of the government, this sale or this exchange that involves sharing for targeted advertising. And that is not allowed unless you offer an opt-out right that's conspicuous and so forth. So this was an area where the government pinpointed this particular activity and said, look, this is a sale. You can't do that without offering appropriate notice and an opt-out right to all the individuals involved. So this is a recent settlement. The reason this is relevant, for med device, med tech, pharmaceutical companies, any company that has a website could find themselves in a similar situation where information is shared, whether it's with Google or with Facebook or with any other advertising organization, that ends up being identifiable personal information. And of course, that comes with it some concerns around the appropriateness of sharing. Is an opt-out right or consent obtained, those kinds of things. And we'll talk further about that in a later slide. So some of the injunction requirements that came out of this, obviously comply with the laws on the books. So comply with the CCPA, comply with the California Online Protection and Privacy Act. Also review those contracts with marketing and analytics vendors and the use of technology that's involved to evaluate, is this a sale or is it sharing personal information of consumers? This is probably something that companies in this space that handle personal data, online should be doing anyway, but this sort of, this of course emphasizes that and requires it in this case. And then of course, providing annual reports to the Attorney General on the status of these compliance efforts. Along with this, in 2024, we saw what's called an enforcement advisory from the regulator that oversees the Consumer Privacy Act in California. And the emphasis here is interesting, but it's applying data minimization to consumer requests. So really what this means is that if you're an organization that must comply with the CCPA and you're receiving a request from a consumer, so you can imagine this is a common activity with this new opt-out right that's been in place through the CCPA. If you have, say, a web form, let's say someone clicks, I want to opt out from the collection and sharing of my personal information. If you have a web form where someone clicks to do that and you collect excess information, say you ask for their date of birth or some additional information beyond what's necessary minimally to comply with the opt-out request, well, that becomes actually another source of potential privacy concern. So the government is obviously concerned about that and raising this in its enforcement emphasis for the year. So really what we can take away from that is if you're designing one of these opt-out mechanisms, really consider what information do we actually need to process one of these requests and take care of that accordingly. Otherwise, the government may look into that and have further interest. So on the federal enforcement side, the Federal Trade Commission has been very active. And if you look through the FTC privacy and security enforcement cases, we can see a huge list over the last year and several years of whether it's lax cybersecurity protections or what we'll talk about today is sharing of personal information with ad tech. There's a variety of different areas where the government has been active and concerned about privacy. And so this particular case, United States versus Monument, was a recent filing where the government looked into some practices of a alcohol kind of addiction treatment center or application. It's an online service where they were collecting a significant amount of personal information and linked to folks who are having substance abuse issues when it related to alcohol, and then sharing some of that information because they wanted to advertise their services through Facebook and through other similar tools. The government noted, even though Monument was approaching this with, well, hey, we have all this information, we have some specific types of information that relate to these individuals, but we'll hash it first. So we'll take it so it's not identifiable. It's kind of broken up into this particular kind of code that we can share with Facebook, and then Facebook will then advertise to these folks using this data. It's de-identified. That was kind of the thinking, and that tends to be the thinking in these cases. But the FTC said, well, you are sharing information that Facebook can re-identify and then confirm is about these individuals and to market to them. And it also informs Facebook of particular health-related status of these individuals because of the context, because of the kind of information that's shared. Therefore, the FTC took the view that this is still sharing of health information with an ad tech company. It's not consented to by the individual. It's not something that's been properly disclosed and notice provided to the individual. And additionally, the agreement doesn't protect the information the way it would if it were being shared appropriately. So this is, if the court agrees to the stipulated order, this would be one of those cases where there would be significant fine, some significant agreement to do different things to satisfy the government's stipulated order. So I'll just read a brief excerpt from this. So between January 2020 and December 2022, Monument used Meta's advertising platform to group the users that had identified to Meta via custom events. These custom events were things that said something about the treatment status or the payment status of the individual patient into groups known as audiences. Oftentimes the Monument gave these audiences names that further identified to Meta that they had signed up for the service, and thus alcohol addiction treatment. These would be tags like paid sign up in the past 180 days or sign up paid. So basically there's some kind of identification of this person as part of the services provided by Monument. And then Monument sent advertisers to users through these audiences, which were created through the Meta platform, and used the audiences to find similar Facebook users and target them with advertisements for the service. So if you're familiar with how these marketing activities work through Meta, you would be probably aware that many companies take these kinds of approaches to do marketing. The FTC is saying if there's any health-related information that gets exposed through this process to Meta, you're potentially violative of the FTC, the Federal Trade Commission Act. So some key findings and things to take away from this as we think about the health industry in particular. So you can see here, there's a few different things that were stipulated through the order, and that includes Monument has to identify the user data it is shared with third parties. So one of the key findings that the FTC noted through its evaluation is that many pieces of individual data were shared with Meta without Monument even tracking exactly what it was sharing, because it wasn't thinking of this as personal data, it was simply sharing it. And so it couldn't even go back and identify who was affected by this. So the FTC is asking Monument to identify the user data it shared and then direct third parties that it shared it with, so Meta, et cetera, to delete that personal data. Monument has to inform the consumers who weren't already notified about this disclosure. So essentially provide notice, like a breach notification to these individuals that were affected. And then Monument has to implement a mandated privacy program. So there's lots of elements that go along with that, but again, this is a general requirement that the FTC is mandating. And I won't dwell too long on this one, but we've talked about BetterHelp before. Ultimately, this highlights how the FTC looks through the lens of an unfair and deceptive act or practice to identify privacy and cybersecurity violations. And this is a very notable amount of the settlement was 7.8 million. There was a significant concern again around sharing sensitive health data for advertising purposes. So it echoes really similarly to what we saw in the Monument case. So I like to highlight that to really drive home the point that sharing for advertising purposes can be a significant risk and result in violations if not handled properly. So again, the FTC alleged in this case that the company, which again offers services towards a sensitive population, health-related, in this case mental health services, that they promised to keep health information private and use it only for non-advertising purposes, and list some of those things. But then they actually did use consumer email addresses and the fact they'd previously been in therapy to tell Facebook to identify similar consumers and target them with advertisements for the service. So again, similar to Monument, the FTC is really focused on these kinds of cases and looking to really cut back and prevent companies from using information this way. And similarly, or as a result of the settlement, BetterHelp was required in that case to align with a number of different requirements, and including, in this case, annual certification of compliance with the order. They were supposed to implement a mandated privacy program, do third-party risk assessments of privacy, and so on. So there's a significant burden that follows one of these violations. I would point out most of these things are controls that would need to be in place to prevent one of these violations in the first place. And that's partly why they're being instructed, but these are part of the mandated follow-up to the settlement. So we'll just say a few takeaways here. So the key here is really look at what you're sharing, whether it's with ad tech, whether it's with other third parties. Consider whether you have consent from the consumer, and don't assume just because the information's hashed or potentially anonymized that the FTC will agree. We've seen a significant emphasis recently on this hashed information and identifying that as not necessarily de-identified in all cases. And that's a key element of this. We didn't talk about it today, but the FTC has been active in cybersecurity enforcement, and that's been for a matter of decades now. So be aware of cybersecurity as a risk, not only from a business continuity and so forth standpoint, but also the enforcement activity from the FTC is active in that area. And we'll stop there. A few other considerations just to keep in mind. We don't have time to dig into these deeply, but there have been a number of class actions and other litigation activity, particularly around a couple of California laws, like the California Invasion of Privacy Act. We've also seen active litigation around the Video Privacy Protection Act. And these are laws that aren't necessarily current in the sense that they address technology that we use today regularly, but they have application potentially to that technology in some unique ways. So we're seeing lawyers in the plaintiff's bar who are identifying opportunities to bring class actions or other litigation based on the way websites are operated, the kinds of information shared with third parties, whether that's through video players or other particular things. So that is a key element here. And there's been some settlements that have kind of avoided taking these to conclusion. So we don't have a strong case law kind of determining, okay, these are now, something we don't have to worry about anymore. We do have some concerns about these still. So be aware that there are some elements of these class action lawsuits that are directly relevant to website operation and how companies use personal data in that context. And we'll continue to give updates on that as we have more information. So pause there. Any questions, feel free to ask them in the chat, either for me or Oliver. Otherwise, please do reach out to either of us. Our email addresses are in the presentation, which we'll share later following this. All right, I don't see any questions. But definitely, please, I know it's hard sometimes to think of them on the spot, but if you think of a question in the next week or two, please do reach out. Feel free to ask us about it. Happy to answer those questions. Otherwise, thanks so much for joining. We're really thrilled to have an opportunity to share with you. It's been great, Oliver, to connect with you and talk about this presentation and share these key insights.
Thanks, everyone.
Thank you. Take care, everyone.
Bye-bye.